H-1B cap filling and lottery for 2025. That's right, friends. I know there are a lot of issues going on, whether it's compliance, multiple registration issues, and even recommendations. So we're going to touch all of these topics. You just have to stay with us. Hello, everyone watching us today. I'm Nipasa Pradhan on Immigration and Jobs Talk Show, and I'm very happy to be a day early today. I mean, it's Thursday. I know we normally meet on Fridays, so very happy to tell you that we are going to be joined by uh, Attorney Chand Parvathaneni for the first time. And I think without further ado, please help me welcome him. Let's get to know him. A big hello to you, sir. Welcome to Immigrations and Jobs Talk Show.
So much for inviting me here today.
So before we get on to the topic, we would love to get to know you a little bit. Please tell us about yourself, Latonya.
Sure, Nipasa. And thank you once again for having me over today. And my name is Chand Parvathaneni. I'm practicing as an attorney here in Dallas area, Dallas, Texas, since 2011. I've been in Dallas area since last 23 and a half years, since 2000. Been practicing for almost more than a decade now. I've helped in representing more than 500 IT companies, helped in filing more than 20,000 H-1Bs. So I have a lot of extensive experience in employment-based immigration filings, seen thousands and thousands of H-1B filings and green card filings that I have helped file for IT companies. So hopefully I can use my experience with working with IT jobs, IT companies, and the shortage in IT industry, uh, how people from India are able to fill in very highly specialized jobs. These are not easy jobs, highly specialized, very high paying jobs. How they're coming and contributing to US economy, and how all of us have this thing called compliance. We have to be in compliant with the laws of the country. So I think the goal today is I'll share my experiences, my knowledge, and see how all of us can be compliant with the laws, and at the same time, uh, people can have a career in USA and uh, just keep contributing to the IT industry in the end.
Absolutely, without any doubt. And today we are going to touch a lot of issues people have been going through these past years and currently as well. So it's going to be a great show today. Folks out there, stay with us, whether you have joined us in Facebook, LinkedIn, YouTube. And I would just like to tell you that if you have any questions or queries, and the best thing is we have Attorney Chand himself today with us, who is going to be very happy to answer your questions. So whatever you have, doubts or anything you want clarification for, please drop in your comments in these platforms and we'll be very happy to take up. And yes, today's topic is H-1B cap filing and lottery for 2025. So would you like to just give us an overview what is actually happening uh, with H-1B filings?
Sure. So a lot of interesting things have happened in the last, especially the last 2 3 days. USCIS came out with a very important announcement. We have been waiting for that announcement for some time. The reason for that is March. March is when the cap filings, the lottery process, it happens every year. It's been happening for the last 4 years. And prior to that, we used to have paper filings. There was no electronic registration process before that. And in the last couple of years, last 4 years, we have been having this electronic registration where you register before doing the actual filing, and USCIS initiates the lottery. And as we have seen in the last couple of years, there has been a rampant misuse of the lottery system. And what has happened is the way the USCIS has designed the system, it was very easy to game the system. Multiple companies were filing for the same beneficiary. And there are current laws that say, yes, multiple companies can file for the same beneficiary if they're truly independent and they're truly bona fide job offers. However, what was happening in reality is that multiple companies were colluding together. they did not have a bona fide job. So they had only one job. They were colluding together, and the goal was to increase somebody's chances in the lottery. So what USCIS has done is they went back, they created a draft proposal, they published a draft proposal last October. They had a bunch of changes that they wanted to make to modernize the H-1B program. And finally, they came out with some final rules. They did not make all the changes that they said they were going to make, but at least what has happened is they came out with some rules, some changes, and the bottom line is that now they have finalized what is called as a beneficiary centric registration. So next month, month of March, the registration process will start. USCIS has confirmed the dates this week. It's going to happen from March 6th to March 22nd. And USCIS confirmed that this year, people will not be able to game the system. Everybody has exactly equal chance, whether somebody has 10 job offers or a single job offer. They're going to be treated the same in the lottery process. And what that means is everybody has the exact same chance of success in the H1B lottery. So that's a great rule that came out this week. That was the good part. There was also some bad news. The bad news was the H1B fees was getting hiked drastically. There is a huge increase in the H1B filing fees. There is a huge increase in the H1B registration fees for the future from next year. So the fee increase was the bad news. The good news was the H1Bs are going to have a beneficiary centric lottery, which is a very good system. And also another good news USCIS came out is they're going to have e-filing. So right now it's a very cumbersome, a very tedious process. You have to send a physical copy, you have to FedEx it. There's a whole bunch of manual steps that are involved. Going forwards, from April, USCIS has announced that they will be allowing e-filing. So that's a major change in the USCIS process. So I think a lot of important updates that have happened in the month of January.
Absolutely. It looks like we have to pray, for luck to favor us. And let's pray very hard. And I hope that, you get it this year somehow, since we all have equal chances, right, Attorney?
Yes, that is correct. I mean, everybody is going to have the same exact chance. They're going to have only one dip in the lottery. Previous years, they had multiple filings, they had multiple dips in the lottery. This year, no matter how many job offers they can have an offer from Microsoft, they can have an offer from Tesla and Google, the same guy. But they will have only one chance, one dip into the lottery. So it's a fair system
All
for
right.
sure.
All the best, all you folks out there who are in this, and good luck, I would say. So, Attorney, can you explain the H-1B cap for fiscal year 2025 and how it differs, from previous years? And of course, what are the implications of the proposed H-1B pre-registration fee hike from, $10 to $215, a huge hike, for the applicants and sponsoring organizations?
Sure. So the good news is that the $215 hike, that is luckily not implemented for this year's cap. It is going to be from next year's cap. The reason is all the fees increases they are getting into effect from April 1st. And since this H1B registration process, the lottery is going to happen in March. Luckily, for the at least for the registration part, the e-registration part, there is no hike in the fee. The fee is still $10 for each registration. And going into the process, so USCIS, they've announced the dates. The registration process will start on March 6th. It will continue until March 22nd. So between March 6th and March 22nd, only the companies can enter somebody into the registration. So if a company has a bona fide job offer, they're allowed to register. So the company has a portal. They have an account in the My USCIS portal. They go in, they enter the beneficiary's passport information. It's a very simple process, and that is not changing. So the way it works is you go in, you enter the employee's passport information, you specify if somebody is coming under advanced master's cap or a regular cap. You mark it, and then you pay $10 fee. It's a very simple process, and this process is not changing. It is exactly same as last year. That the filing, the registration process, the fee is still the same. The fee is still going to be $10, and then the company just submits the registration, and they get entered into the lottery. The only thing is, companies have to make sure they have an account with my USCIS. The companies have to make sure they file within the window. The window is March 6th. They can't do it before March 6th, and they cannot do it after March 22nd. So they have to make sure they fit the schedule, they fit the time window. And as long as they're doing it, the process should be pretty smooth. And again, if we went back a couple of years before this electronic registration started, it was a very cumbersome process where they just had to file the first 5 days of April. So before 2020, what used to happen is, the companies, they had to prepare the entire petition, the entire I-129, along with the LCA, everything. Submit this between April 1st to April 5th. That was the process back then. And if you don't meet the filing window, April 1st to April 5th, they're out of the queue. So that's how it used to be before. And now, April 20, this CAP 2025, and the future at least, it's going to be e-registration. So e-registration has been happening since last couple of years. It was a mess last year. It was a mess last year because USCIS came back and said they had 800,000 registrations. We only have 85,000 slots. So there's a lot of demand. But then they came back with the data, and then they said 400,000 registrations were multiple registrations. So probably something is going wrong. So the data is too erratic. The data doesn't show that those are all genuine registrations, which is why
Mhm.
going into 2025, the process got refined. It'll be a beneficiary-centric registration, and I think this is the time. Anybody that is looking for a CAP filing, make sure you start communication with your employers. Make sure they have that information, and do not miss the window, March 6th to March 22nd window.
Mark your calendars, folks out there. And thank you, all you folks, wherever you are, joined us, YouTube, LinkedIn, and also Facebook. Very nice. Sam Dilton, hello to you too. He's on YouTube. And for the rest of you who are asking questions, please stay with us. We will be taking up after I have my questions asked because I have prepared some, and I'm sure Tony Chand has a lot to speak about as well. So let's move on, to this system, this new system that's going to happen from the coming year as well. I mean, the online filing system, how does the new online filing system for H-1B petitions effective this February aim to improve the application process? And what should applicants and employers be aware of regarding the transition of a completely paperless H-1B petition process?
Sure. So, for all these years, we have been doing paper filings. So the companies are used to the paper filing. The attorneys are used to doing the paper filing. So paper filing is where you physically type in the data in the I-129, you print it out, you get the manual signatures, you print out all the documents, the supporting documents such as offer letters, the mark sheets, the transcripts, the passports. You put everything as a physical copy, and then you have to figure out where to send it because depending on the company, the location of the company, uh, the H-1B packets have to be sent to multiple locations. If a company is in Texas, we send it to one Texas service center. If a company is, for example, in New York, we have to send it to a Vermont service center. So there are multiple places. So right now there is too much of manual effort involved. We have to write a check, a manual check. So right now the process is too much manual work involved, too much prone for manual errors. We have cases where sometimes there was a human mistake, the file comes back. So a lot of issues. Going forwards, the e-filing system. So the e-filing system is a major initiative. It is going to streamline the entire process. So USCIS, they said starting April 1st, we will be able to e-file. So when you say e-file, all we are doing is we are putting in the data electronically. We are uploading the documents electronically. We are paying the fees electronically. We are not worried about mailing it to the right service center. We're not worried about putting the wrong fees. We're not worried about missing some pages during transit or something happening to the FedEx in between. So it's a clean process, and it should make it more efficient From the employer's perspective, what it means is it's a new process, and the portal is not live yet. The portal will be live in a couple of weeks, and USCIS has not opened up the portal for public yet. But once the portal is available, the main things that employers should be looking out is are there any size limits, because the copies have to be uploaded as a soft copy. So definitely there will be some size limits. So look at the size limits, look at the formats they require, look at the mandatory documents. So we still don't know the exact way they will do it, but definitely, I mean, from a process perspective, e-filing will definitely be a lot smoother. The first couple of months definitely will be a challenge, because this is the way that filings have been done so far, and all of a sudden USCIS said they will let people do the e-filing. So we have to wait and watch. That being said, the main thing is people can still do the paper filing. So USCIS said, at least initially, they will let e-filing or paper filing. They will give an option for both. So at least until the employers are comfortable or the attorneys are comfortable, people will be able to use both the systems. And what that also means is, tomorrow for the employees, when they go for the visa stamping, things are very smooth. Everything is right there in the USCIS portal. Everything is, the case management becomes super easy. So when documents get shared between the petitioners and the employee, because they have to have those documents when they go for visa stamping, things are expected to be a lot more smoother. There is no hassle about a scan getting missed, uh, because the scan has to go to the employee. And previously we had cases where the file was corrupted, and the employees could not be given the original file, etc. So with e-filing, all the problems are resolved. So things are looking better. The process, H1B process, it's a tedious process. Hopefully, with these new changes in 2025, things should be a lot smoother.
Right, right. And let's look forward. I think it's exciting, this whole process. And I think all we can do is look forward for it for sure. And let's move on to, the organizational accounts feature. How do you think will the new organizational accounts feature in H1B, the e-registration platform, benefit the applicants and also their legal representatives? So also if you have any specific guidelines or best practices, for using these organizational accounts effectively, it'll be great, if you could give some tips as well.
Sure. So for anybody that's in this H1B process, organizational accounts, this is a new concept that USCIS just came out in the month of January. So this is a new feature, and we still don't know how it's going to work. But USCIS announced this important update in January and gave an idea about what is going to happen. So the organizational account, this is a company account. So USCIS is saying they will let the companies create an account, organizational account, in a new portal that will be released in February this month. They said the portal will be live on February 28. So February 28 is the day all the companies, because this is accessible only to the company that is filing H1B petitions. So any company that is filing a H1B petition, they should be on the lookout. Starting February 28, the companies will have access to it. And the companies are expected to create an organizational account. So organization is the company. So the company should be able to create an account. And this is the account that is mandatory if they want to do e-filing. So the company, this organizational account, is an account that the companies will create. And once they create this account, they will be able to create multiple groups. The reason is you will have an admin, and then you will have these multiple groups. What USCIS is saying is one person in the company might be responsible for reviewing the petition. One person might be responsible for making any edits. One person might be responsible for paying the fees to USCIS. So these groups will let them handle those tasks, giving some permissions, and these permissions will let somebody do some tasks. And these organizational accounts also will have a process where they can link it to their attorney, to their law firms. So that way, the organizations can coordinate with the law firms, and together they will be able to do the H1B filings. So again, this is a new feature that just got announced, but this is going to entirely change the way the companies and the law firms are filing the petitions in the future. Starting February 28, is a time when all companies should go in and try to create these accounts. And these accounts are going to have all the case data. And tomorrow, the companies will need to probably share that data, at least the relevant beneficiaries' data, to the beneficiary that is going to be required for their visa stamping purposes.
All right, very interesting. And hopefully, folks, you are going to be very ready and excited for this new process that's coming up for CAP 2025, the H-1B process. And of course, I can see a lot of people commenting their questions. Very nice to see, and definitely will take some of them and everywhere YouTube, LinkedIn, and Facebook. Thank you, folks, for joining us. There's a LinkedIn user asking, I'm sure he would like to meet you, Attorney Chan, there. So he's asking, where is your office located in Dallas, Texas?
So we are in the north of Dallas, and we are like by the intersection of I-35 and I-121. It's a famous intersection. So we are like
Mhm.
right in the middle of the Dallas Metroplex.
All right. I hope you can go find a Tony Chan. Then, moving on, I think since it's a new selection process, let's get to know a little bit more about it. And if you could discuss, the proposed beneficiary-centric selection approach and, the potential impact on the H-1B lottery selection process. And of course, how does USCIS plan to address the issues of multiple registrations for the same employee, by all these related entries. If you could just explain, it would be great.
Sure. So we are hearing about this term beneficiary-centric approach in the last 3 4 days, and that the reason is USC has confirmed that this year they're having a major change, and the major change is they're going towards the beneficiary-centric approach for the lottery process. So all that means is, so last year, the way they handled things was they looked at the company registration. So if an employee has multiple offers, multiple registrations, they got into the lottery multiple times because every company got a dip into the lottery. And this year they're saying it is not company centric. The company which is trying to hire the H1B beneficiary, it is not that process, but it will be a beneficiary centric. And what that means is they're going to use the passport number, and they're going to see uniquely how many number of beneficiaries have been registered, and those are going to go into the lottery pool, and they're going to initiate a lottery based on the unique beneficiaries through their passport numbers. So the layman answer is they are putting everybody in the lottery only once, and every beneficiary will have an equal chance. So, for example, you have 400,000 beneficiaries, and they are selecting, say, approximately 100,000 selections. So, everybody is going to have a 25% chance of getting selected in the lottery. Last year, it was different. It depended on how many number of registrations everybody had. In a beneficiary centric approach, everybody has equal chance. So total number of slots divided by the total number of unique beneficiaries, that is their probability this year. So it's a more straightforward, more streamlined approach.
Okay, and um, all right. So, folks out there, if you want to get in touch with Attorney Chand, if Attorney Chand, could you please give out your mailing address and also your phone number? It would be great.
Sure, sure. So our phone number is 972 and our email address is law at the rate of sbblawfirm.com.
Perfect. I hope you can find Attorney Chand and also ask your questions directly. And if you need some clarifications or need an attorney, I think he is your stop. So go check him out. And let's get to the issues, the compliance issues that is going on. What are the major compliance issues employers and applicants need to be aware of, while filing for H-1B visas? And yeah, just that first.
Sure. So compliance should be on the minds of everybody. Should be on the minds of employers. Should be on the minds of employees. Should be on the minds of attorneys. Anybody that is associated with this process. Compliance is super important. If companies don't are not compliant, they can lose their ability to file H1Bs. If the employee is not compliant, they can lose. They can jeopardize their future visas. They can jeopardize their future H1B transfers, extensions, any of those things. So just to kind of quickly summarize what is compliance from a H-1B perspective. Employers, you're supposed to make sure you pay your employers on time. You have to make sure you meet the LCA requirements. You cannot pay anything less. You cannot bench anybody. Benching is prohibited even for a single day. If somebody is benched, you go to DOL, you complain to DOL. DOL is going to make sure employees are paid. So very important, no benching, and that is what employer has to make sure. Follow the LCA, 100% compliance with the LCA. Another very important thing, everybody that is on H1B, they should get a copy of LCA from the company. This is not a recommended thing. It is something that is mandatory. The employers don't have a choice. The employers have to share the LCA with the employee. So if you have any employer telling you that they will not share the LCA, tell them that the DOL rules specifically require the employer to share the LCA copy to the employee. Okay, there is no choice. So LCA is something that every employee should have. And the reason I say that is because the employee should know where they're supposed to work. The employee should know how much they're supposed to get paid. From a compliance perspective, the employee has to make sure they're getting paid. The employee has to make sure they're only working from the metro area where they're supposed to work and in that particular occupation. So it's very important. So if somebody has to be compliant, make sure you look at your LCA. The LCA will give you a major clue on what you're doing, whether it is really compliant with your H-1B filing or not. Okay. So overall, follow the rules, be compliant. And in the H-1B world, LCA is a very important document. Look at the LCA and make sure you're only working as per the terms of the LCA.
All right. And, if you could just highlight once again, all the legal requirements to avoid rejections or delays so that people can note down and keep in mind.
Sure. So, uh, so there are two things: one, the lottery process, and one, the filing process. So during the lottery, so the rejections that typically happen are if the fee payment gets declined. If the fee payment gets declined, it will be an automatic registration rejection. So be very careful. We had some clients where they used a credit card and later on found that their payment got rejected. So be very cautious about that. Another important thing is duplicate filings. The same company cannot file the same person twice. We had some cases last year where a company accidentally filed the same employee twice because they did not check and see the list. So if a company files for the same employee twice, it is going to be an automatic rejection. So companies be cautious. And then for the H-1B filing. So the H-1B filing has some mandatory documents, and this is more on the employer side. So the employer has to ensure that they make sure all the mandatory documents are provided, the right fee is paid, because if the right fee is not paid, the filing will get rejected. And if the filing gets rejected and the deadline has passed, they'll be out of luck. So there are a couple of things. The filing is a little bit complex, and that is why the employers typically have to get started as soon as possible, as early as possible, and ensure that the filings are done appropriately.
All right. All right. Well, I hope that folks out there who are applying for their H-1B visas, whether you are organizations or candidates, and I hope you will keep in mind all these things, so that you will avoid rejection and delays. And Attorney, let's move on. We have so much to talk about today. And
Yeah.
I think the most interesting thing is this lottery process. So, the strategies for handling the lottery process, if you could just explain to us a little bit more, what strategies would you recommend, for employers when submitting multiple qualified candidates to increase chances of selection in the lottery?
Sure. So a lot of companies will submit multiple candidates because they have multiple openings in their company. One has to be very cautious. A company can submit a registration only after they make some attestations. These attestations are very important. The reason is if the attestation is incorrect, inaccurate, or a misrepresentation, the company is going to be in trouble. The registration will be cancelled. Even the approval down the line could be revoked. So the main things are when they're submitting multiple candidates, make sure every registration is a legitimate registration. Make sure there is a bona fide job offer linked to every registration. Make sure nobody's colluding with anybody. So this year, even though it's a beneficiary centric approach, that still requires that nobody collude with any other company. What that means is some company cannot collude with another company and just file a registration. So the registration should be legitimate, should be bona fide. So the main thing is the attestations are very important. Everybody has to read the attestations that they are signing off on during the registration process. Make sure they're met. Doing so, they're compliant, and being compliant, they're good to go.
Okay. And how important you think is timely filing of applications and what can be done, to ensure readiness for submission as soon as the lottery opens?
Sure. So the lottery opens on March 6th, ends on March 22nd. There are two dates where I think employers should not rush. That is March 6th and 22nd. Do not try to file everything on the first day. Do not try to file everything on the last day. Because not what we have seen is the first day everybody tries to rush in, the system is super slow, and also people tend to make mistakes on the first day because they're rushing. Last day is too risky because last day the website will stop at 12 noon EST, so it is too much of a rush. Try to do it during middle of the registration, so somewhere around 10th to 15th is ideal time. That way people get enough time, and they don't have to rush. You file within the timeline, everybody has the equal chance. So just there is no need to rush, but make sure you do with some buffer in hand. That is for registration. For the filing, the filings will start on April 1st, and the deadline is June 30th. We have at least 50% of our cases typically being filed during June 15th to June 30th. The reason is employers don't even do anything for April and May, and June is when they start filing LCAs. June is too late. We highly recommend that people do not wait until the last minute of June, but try to get the filings done, at least, if not April, at least in May. People should try to get all filings done by May to be on the safe side. Even though USCIS is giving everybody 90 days, don't wait until June. Okay, so we want people to be proactive. Don't have to do everything on day one, but definitely not at the last minute and not right on day one.
Absolutely. I mean, for folks out there who always keep it to the last moment, just before the end of time, let's not do that as well. Let's keep some time in hand and do all things right. Let's not rush too much. Let's not wait till the end. So I'll just say all the best and see that you do it in that time frame. And yes, moving on, let's touch on the next topic, and that is the recommendations for applicants and employers. Based on the changes of the fiscal year 2025, what are your top recommendations for applicants and employers to improve their chances of success?
Sure. So the main recommendation is the educational requirements or the work experience requirements, because people are highly qualified. H-1B program is not a program where people are paid cheap labor. H-1B are highly qualified, highly specialized employees. People have very good degrees, highly degrees, a minimum of a bachelor's. A lot of them have a master's degree. A lot of them have a lot of experience in big companies. So what that means is the major recommendation is hire only the top talent because you're really paying them a high salary. And USCIS, they're in the process of changing rules this year. There are some things that are going to change. And USCIS is heavily focusing on employees' credentials. So the employee qualifications are super important. So when a company is hiring people with a diverse set of skills, that is very good. But the companies have to make sure people have the right skills. And from a USCIS perspective, they are looking at the educational equivalency for IT jobs, especially. They are looking for at least a bachelor's degree in computer science, information technology, or something that is closely related. So this is important. And we have people with 3 year degrees, sometimes people with non-related degrees, for example, civil engineering, mechanical engineering. In the USCIS current regulations, yes, those people will qualify if they have a lot of IT experience. So if they have a lot of IT experience, you can still use that experience, document that experience, and along with professor evaluations, you can use it. But what that means is USCIS has very strict requirements where the company has to prove that somebody is qualified. If somebody has a computer science degree, it's very easy. They don't even have to prove experience. Even without proving experience, they're qualified. But somebody that has a non-relevant degree, companies have to be cautious. But most of the time, they're hiring them because they have a lot of IT experience. And what that means is document that experience. provide experience letters, provide proof that they really have skills. What means to everybody out here, have a degree that is not your evaluations done. Get your experience, get proof your that is highly important.
Right. And how do you think should employers align candidate selection with their business needs? Whether it is by ensuring a diverse set of skills among the selected candidates, or how do you suggest?
Sure. Another common question that I normally see uh, is USCIS particular about a skill set? For example, I have a guy who has a computer science degree, but he was a Java developer and all his experience is as a Java developer. But now my new requirement for my business is that I need a data scientist with Python skill set. Can I hire him? So it's a common question that we get. So when you are talking about the skill set from a USCIS perspective, they are looking at the educational requirements. They're looking at the occupation. They're looking at the educational requirements. So for say somebody who worked as a Java developer, the company wants to put them as a data scientist. From a USCIS perspective, if the employee is qualified through their education, that is good enough for them. The occupation, what does the occupation require? The occupation requires a bachelor's degree in computer science. USS is good. They are good at that point. The skill set is not something they're going to come and point out because the H-1B requires a specialized worker, and a specialized worker is somebody that has at least a bachelor's degree in a relevant field. So the minute somebody has the right educational skill set, the company can always change their skills. They can train them in different skill sets. They can change their skill set. So more than the skill set, the companies should be looking at what is their educational background. If their educational background or a combination of their work experience in education is equivalent to a US degree, US 4-year degree, then pretty much they're qualified. So the skill set can change.
All right, noted, noted. And wow, I mean, it's been more than half an hour we've already spoken, and I think it's time for a break. We will definitely talk more because I have some more questions, and I can see a lot of folks out there in YouTube, LinkedIn, and Facebook, asking so many questions. So I just say hang on once. And also, if you have uh, if you want to mail me or just WhatsApp me, I also have a telephone number. And you could also mail me at nipa@higheritpeople.com or call me or message me at 408-335-6444. And of course, Attorney Chan Parvathaneni, you can mail him at law at spblawfirm.com or call him at 817-523-8247 and definitely go visit his website spblawfirm.com. And friends out there, hang on because we have a lot to talk about and we are the key to your immigration solutions. And I hope you're smiling because you are getting your questions answered today. So hang on, we'll just go for a short break.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everybody, to Immigration and Jobs Talk Show. It's me, Napasta Pradhan, with none other than Attorney Chan Parvathaneni today, and we are speaking about, the H-1B, the whole process that is the new process that's going to happen, H-1B cap filing and lottery for 2025, of course. And we already touched on many subtopics, whether it's the overview, the filing system, the organizational accounts feature, the lottery selection process, compliance issues, even the strategies for handling the lottery process, the recommendations for applicants and employers. And I hope that you are with us today and having your questions answered. So thank you so much, Attorney Chand, once again for patiently answering. We have a few more things to talk about, and of course, we will move ahead with the questions from all the folks out there who are watching us right now. Thank you so much for being with us. So um, yeah, let's move ahead to navigating fee hikes and the financial implications. With the significant increase in the H-1B pre-registration fee and overall visa fee hikes, how should applicants and employers plan their finances? What do you suggest?
Sure. So, the bottom line is the fee is increasing drastically for the H1s, but the applicants should not be the ones that should be paying any fees. USCIS has very strict rules, and lately this is what is happening. We are seeing during site visits or during the consular visa interviews, the officers are specifically asking the visa applicants the question: did you pay for the H1B? This is very, very important. The employees should not pay the H1B fees. There are strict rules that prohibit employers from making employees pay the H1B fees. It's very important because this question is coming up a lot during the site visits. This question is coming up a lot during the visa interviews. They are specifically inquiring, they're specifically asking to see if anybody is paying the employers the H1B fees. So the employees should not be paying any H1B fees at all. So that is very, very important. And that being said, the fee increase is definitely going to hit the employers. For the H1B, every case is going to have an increase of $920 because they have started something called an asylum fee. They're making the companies pay the asylum fee. So in terms of the companies, they're going to see a huge increase in their H1B filing fee, almost by $900. That being said, USCI has said that if a company is small, when they say small, a company with less than 25 employees. So the small employers are getting some kind of a discount. So the small employers will only have to pay $300 additional fee. So the small employers are still getting a reduced fee. So I think overall, I think it's the fee increase is a bad thing because the USCIS fee is very high, already extremely high for H1B petitions. And on top of that, this new fee hike. So I think it is going to discourage at least some companies, even though they have a labor shortage, they really need highly specialized employees. I think it is going to definitely discourage a couple of employers. But again, USCIS is justifying it because they have not really increased the fees in the last couple of years. But they're also, I think, what I think many people are not satisfied is this program is being used to fund the asylum program because it's a huge hit. The $600 asylum fee that the companies will be charged, this is a burden for the companies. So overall, I think the companies unfortunately will have to absorb that hike. The only good news is this fee hike is not until April 1st. So any company that has any extensions, any amendments that are required to be filed, file it immediately before this hike is in effect. This hike is in effect only from April 1st.
All right. So I think I'll just say you should play safe and yeah, play well. I'll say all the best to everyone out there looking forward for this one. And if you could tell us if there are any strategies, to mitigate the impact of these fee increases on the overall cost of the H-1B visa process, Tony.
Sure. So the main thing is it's a very expensive process. Now with the fee increase, it is even more expensive process. So what that means is one cannot afford to get a denial because it's a huge loss of the fees. So what that means is companies have to be extra careful, make sure they hire the right people, make sure they don't miss any important documents, because they cannot afford a denial because things are so expensive. So during your hiring process, during your filing process, make sure you have proper checks and balances, so that way the case is approved. And just be cautious, because it's not only the initial filing. The companies also have to figure the costs of filing future amendments, future extensions. So there is a whole lot of money that gets spent on these H-1B filings throughout the lifeline. So just be cautious and try to make sure at least the petition is as accurate as possible, so people can afford surprises and loss of uh, this large amount of fees that they have to pay.
Right. Absolutely. And I hope that folks out there, things are clearer. Do proper research before you get into the whole filing process, because you cannot afford to make any mistakes, and do it in one go with all correct input. And I'll just say all the best. I hope the luck fairy finds you as soon as possible. And Attorney Chand, if you could also tell us about the timeline and key dates, if you could provide an overview of the expected timeline for the H-1B visa 2025 process, including the registration submissions, the lottery selections, and even the petition filing periods.
Sure. So registration is March 6th to 22nd, and then the filing will start on April 1st. April 1st to June 30th is the filing period. But keep in mind, cases that get filed in April, they're going to get very, very quick adjudication. Not many people file in April. So what we always recommend is file as early as possible, mid of April, probably end of April. April cases, typically, most of the cases, we see adjudications happening in 1 to 2 months, very quick. The reason is there are few filings. So as you wait, as you keep delaying your process, as you get to June, normally what happens is we see adjudications take anywhere between 1 to 6 months. So once you file the petition, you are going to see anywhere between 1 to 6 months. Uh, More early you file, probably your case is going to get adjudicated a little bit more faster. Cases that get filed at the very end, because June 30th is the deadline, you're probably going to see as long as 6 7 months of time to see the adjudication. So be proactive. And in terms of filing, what's also going to happen is some cases will get an RFE, a request for evidence. If you get a request for evidence, you will have 90 days to respond in terms of the time period. And once you respond, again, USCIS will again take their own time, anywhere between 1 to 6 months. So account for all the times, the time to file, again, the time to see the adjudication. And again, if there is an RFE, make sure you have time to get the approval. The reason that is important is because a lot of folks, their OPTs will expire in between, and their status will expire in between. So make sure you account for that time, and you look at all these timelines when you go for your filing.
Okay, folks, keep that in mind. And if you could also give them a few tips, if how should applicants and employers prepare in advance to meet these key dates effectively?
Sure. So one most important thing I want to tell everybody is look at your passports. You should be looking at your passports right now. And if your passport is expiring very soon or in the next couple of months, go and apply for your passport. The registration will start only after a month. So if you start now, by end of February, you can probably get your passport renewed. So everybody look at your passports. Passports are super important. Do not be in a case where you're using a passport that is expiring in a month, and then you have a new passport in a few months, and all those confusion. So try to get a new passport. First important advice. The second important advice is everybody should have a copy of their degree and their mark sheets. We come to a point where we are filing their petitions in the month of April, May, June. They come to us and say we only have mark sheets. We don't have the actual degree copy. Or they will say we have the actual degree copy, we don't have the mark sheet. So to avoid any issues at last minute, this is the time. Go look at your mark sheets, look at your degree copy. We need both, not just mark sheets, not just a degree. So this is very important. If you don't have it now, now is the time to apply and get it in time. So get your degree certificates, get your passports, get your mark sheets. Everything should be ready by end of this month. That way, you don't have surprises. People who don't have a computer science degree, make sure you get experience letters with the job duties. Everybody should have an experience letter, not an offer letter, but experience letters. So now is the time, because you don't want to wait until the last minute. Start working with your ex-employers, previous employers. Try to get your experience letters documented. It is highly important. So doing these things, at least you will be ready. Passports, educational documents, experience letters. These are the most important documents for majority of the folks. And then there are folks here on F1 visa. Anybody that's on F1 visa, make sure you have access to your 983s. Make sure you have access to all your I-20s. Make sure you have access to all your pay statements while on OPT. If somebody has taken CPT, make sure you have your CPT agreements with school, CPT I-20s, proof of all your tuition records, proof of all your attendance records. Don't wait until the last minute. So high level, make sure you gather all these documents, and that way you have very, very less surprises when the final time for the petition filing comes.
Wow, I mean, thank you for those advices. I think this is why my colleague Dan Nandan says, if you go to a hospital, don't talk to the patient, talk to the doctor. So, viewers and listeners, all folks out there who have joined us, I think you should just go talk to your lawyer or attorney, and especially Attorney Chan Parvathaneni himself. So, yes, one last thing what we should prepare, looking ahead. So, considering the ongoing changes and challenges in the H-1B visa process, what future trends or further changes do you anticipate for the H-1B program beyond 2025, Attorney?
Sure. So the H-1B program will always be there, because H-1B program is such an important part of US IT industry. It is highly essential, and it contributes a lot to US economy. So the employees, the H-1B employees, will always be in demand. The core skills they bring to the country, they're always going to be in high demand, and the pay scales are going to be very high. The H-1B employees, the pay scales are very, very high. It's not cheap labor at all, and everybody knows that, because the LCAs and the average salary, if you look at the average salaries that I normally work with, are around $100,000. So these are very highly specialized, highly qualified employees. So the program will be there into the future. But the future trends, you can definitely expect more site visits, because USCIS is about to change the way they do their site visits. USCIS, the visa processing. The visa processing, always there are challenges, because they're scrutinizing the applications. They're scrutinizing the social media accounts. So everybody, the main thing everybody should understand is always comply with the law. Be in 100% compliance with the law. Do not ever take shortcuts. The reason is, either on the social media, either sometimes what happens is, when you come into the country, at the port of entry, they take your phones, they take your laptops, they look through the records, even the chats that you deleted. They have ways to get back to it. I hear of people getting deported all the time. I have at least 2 cases in the last 1 month where I heard people, their phones got taken away from them, and when they looked through their phone chats, it was very clear that these guys were doing something wrong. They were doing some illegal part-time jobs during their student status, for example, or they were having some fake resumes and doing some fake interview calls with some companies. It was there in their WhatsApp on their phone. So the government officials, they have various ways to detect fraud. And what that means to all of you is, don't even get into that situation where you're not compliant with the law, because they can easily access your phones at the port of entry. So all these things. So be cautious, be compliant with the law. Understand that as technology evolves, there are more and more easy ways for the officials to find out and detect fraud. So be cautious, always be compliant, and just understand that as long as you comply with the law, you have very great future in US, because in US, the IT skills are always in very, very great demand.
Right. So, folks out there, rules are rules and they're meant to be followed. You cannot miss out on that. And I think one last thing I want to ask you is, how can applicants and employers stay informed and adapt to these evolving requirements and procedures, Attorney? What can they do?
Sure. So I think the easiest way for most of the folks is, on the USCIS website, there is a way where you can request their newsletters and their updates. If you just put in your phone number, you keep getting updates. So I think that is one easy way where you can get updates. On our side, what we do is, we stay in touch with the ILA, the American Immigration Lawyers Association. We get a lot of updates, daily updates from them. We talk to our colleagues. But again, everybody, I think, if you are following USCIS and look at their news releases, that is like one easy way. And I think because most of the folks here are like IT folks, very, very tech savvy, highly experts with computers. So most of the time, I think you guys have access to social media, all these good forums and stuff. So I think, be on the lookout and keep following USCIS news alerts. That is the easiest way to keep in touch with the law. And the law is very clear. You cannot be ignorant of the law. You cannot say, "I didn't know that was the law." You have to know the law, because otherwise you'll get penalized. So this question is a very important question. People should keep themselves updated with all immigration laws, because tomorrow they cannot argue that they did not know about the law. So there's this concept in US that says ignorance of law is not an option. So everybody, it's your responsibility to keep yourself updated with the law.
All right. So keep yourself updated, all you folks out there, and all the very best. But we still have one more month, like Attorney Chan was saying. So if you need to renew your passports, if you need to go register a new passport, go do that. You still have some time in hand. And I'll just say all the very best. All good luck to you. And I think I have come to the end with my questions, and we'll take up a few questions from viewers out there. So thank you so much. Let's go with LinkedIn for Farhad Ali. Is it necessary to have a project or job in order to file H-1B?
Yes, there is this very, very important concept that USCIS has stated multiple times. You cannot have speculative employment. You have to have definitive assignment. What that means is you cannot say, "I don't have a project. I'll hire somebody. Once somebody is here, I'll find a project." That is speculative. There is this concept of bona fide job offer, and bona fide job offer means somebody actually has work. It could be in-house work, it could be implementation project, it could be a client assignment, third-party assignment, but they need to have some assignment. Purely speculative employment is prohibited, and USCIS could deny a case if they notice that it is speculative employment.
All right. So I hope Farhad Ali in LinkedIn, you got your answer, and all you folks also out there. So let's move on to another question. Which one should it be? Okay, Venkata Sai Kumar Ganta. Hi team, I have 3.2 years experience in production, support and application support. Please let me know, is there any vacancies?
Sure. So again, we work with companies, so we don't really do any hiring. But from your perspective, I'll answer. So you can use work experience along with your education to see if you qualify for a H-1B. So the first thing normally you should do is you should look at your degree, and if your degree is in computer science or IT, a four-year degree, pretty much you're qualified. So you can skip the experience part, but from a qualification perspective. But say your education is not in computer science field, then always add your experience along with your degree. So normally what we see is if you have at least a four-year degree in some field, some relevant field, with at least 3 years or more of experience, then of the relevant experience, then you might be able to go to a professor and get an experience evaluation done. 3 years of experience and a four-year degree, and you might be able to get an equivalent degree in computer science based on work experience and education. And we do it routinely. We combine experience, we combine education, we go to the professor, we get an evaluation done, and then we go back to USCIS and argue that in spite of somebody not having a computer science degree, they are qualified because of this evaluation from this professor.
All right, all right. And let's move on. I hope you got your answer. And let's go to Sunena K. She says she also posted on LinkedIn asking, can we file for H4 for dependents along with H1B?
Yes, and we highly recommend that they are filed together. We don't want people to file them separately. The reason is there was a settlement, a court settlement last year. After that, USCIS has stated that if both are filed concurrently, H1B for the primary employee, H4 for the dependent spouse or their children, if you do it together in the same packet, they are going to adjudicate both at the same time. So it is advantageous for somebody to file it simultaneously.
All right, Sunena, I hope you got your answer. And let's move to Aravind Walak. Walake. Hi, this time only employers can register with nominations, or employers should work with attorney to complete the registration process. What do you suggest, attorney?
So the registration is a very, very simple process. And normally what we do in our law firm is we encourage the companies to do it themselves because the registration is a very simple process. They just put in the passport information, they pay the $10 fee. And that being said, we also work with a lot of companies where we do the registration on their behalf. But there is a two-way handshake kind of a concept. So what that means is we prepare the registration. It goes back to the employer. Employer will have to look through the registration process, and they have to approve it, saying that everything is correct. They have to make some attestations and so on. So either way, it's a very simple process. And typically, even in the last couple of years, a lot of employers do it themselves. And for a lot of them, we do it and we work in tandem with them through this two-way handshake because the registration is simple. The filing is what is complex. So the registration, again, different employers do it differently. The rule is the employer has to have an employer portal. So that is a mandatory requirement. Even if we do it, they still need to have their own portal because that is how the system is designed.
All right, we already have the next question on the screen by Kumar DSIT. Is it still the $10 fee for registration?
So luckily, this year we still have the $10 fee. So the March next month, when this registration process opens up, it is only $10. This is the last year. Starting from next year, it is going to be $215. It is a huge, huge, huge increase. Almost, I think, 2,000% increase. But again, this year, luckily, the employers are good to pay only $10, and this will be the last year where they pay the $10 fee.
All right, and I hope you got your answer as well. And let's go to the next question by Tessa Sam. I was in US for 6 years at a stretch from 2017 to 2023. Visa maxed out in August 2023. I don't have I-140 and returned back to India. Am I eligible for fresh I-1B, H-1B filing for 2024 to 2025?
Sh- Sure. So typically in this scenario, one is eligible after staying out of the country for 1 year. So theoretically, because the start date will be October 1st or later, October 1st, 2024 or later. So in this case, as long as the gap is more than 1 year from the time he left the country, you should be eligible.
Okay, all the best. Let's take a few more. Do we still have a little more time, Attorney Chand? If
Sure, sure.
Okay, this one is from Walter Ryan. Post H-1B withdrawal, USCIS steps. Can H-1B become B1 or B2? If H-1B from September 2022 to September 2025, resigning in September 2023, what about the remaining 2 years? Uh, Minimizing future US visa impact?
Sure. Actually, it's a good question because I've seen a lot of people. People are getting laid off. They're on H1B. They got laid off. They have 60 days. Within 60 days, they have to find a new status. Either they get a new H1B filed, or they have to change their status to another legally allowed status. So what is happening is sometimes people don't find a job in 60 days. If they don't find a job in 60 days and they still have some matters they have to take care of, they have to sell their car, they have to sell their house, or they have some need to stay back in the country. So legally, applying for B1, B2 before the 60-day expires, that is legally acceptable, that is legally allowed. So somebody can, yes, they can convert to B1, B2. They can file for change of status to B1, B2. And as long as they're following the terms, they should be good. The follow-up question I think he has is, I still have 2 more years of my H1B time period left. How do I use them? So the rule is they can use their entire 6 years. So if they don't use their 6 years now, say they go to India right now, they can even use the 2 years down the line anytime they want. So after 5 years, they can come back and use the 2 years on H1B. So the 6 years is something what they can use at any point of time. So if somebody gets laid off, they convert to B1, B2, and say they have to leave to India. In the future, they're still cap exempt because they have not used the 6 years. And down the line, when they find an employer, they can use cap exemption, file a H1B, and again come back to US.
All right. Okay, I hope you got that answer. And now we'll take up Pavan's from YouTube. What is political asylum comes under H-1B filing, and we need to pay an extra $600 for every time we file I-129 for political asylum. What do
Sure.
you have
So
to say?
asylum is another program that the government has. It's an independent program. But what is happening is when H1B gets filed, the employers have to file what is called an I-129 petition. So the new rule says that we have to pay a $600 additional fee, and the 600 additional fee will go towards the asylum program. So the H1B or the I-129, it is not really connected with the asylum program, but we just have to pay that additional fee, and that additional fee will be used by USCIS for the asylum program. So from our perspective, all that means is the additional check needs to be paid as a part of the filing. Other than that, it's like it's not connected to the asylum program.
Okay, and let's take up this next one by G. Kishore. And the question is, I am a student. How's the lottery going to affect me?
So if you're a student and you have an employer, the employer is the one that should register you for the process. So the way it will impact you is this year it is beneficiary centric. So if you have only one job offer versus somebody that has multiple genuine job offers, uh, both of you have the exact same chance of getting picked up in the lottery.
Okay, all the best then. And I think, folks out there, if you have more questions, keep them coming. We will take them up and definitely answer to you. And if you want to actually ask attorney himself as well, you can mail him. I will definitely tell you his mailing address and his phone number. But let's take up this question from YouTube by Nitin Paul. If I switch employers in September 2024 with my current I-140 approved by July 2024, can I extend H-1B beyond 6 years if the new I-140 isn't approved by September 30, 2026, and perm is filed after September 30, 2025?
Sure. So if you have a I-140 approval with a previous company, not your current company, if that approval is not revoked for at least 180 days after the approval, if it is not revoked, there is no problem at all. But even if it is revoked, it should be after 180 days of approval. So as long as it is revoked after 180 days of approval, what that means is you can that 140 is yours to keep forever. So that means you can keep on extending your H1B using the old I-140 approval. So the key is that old company should not revoke that I-140 within 6 months of approval. If not, you're good to go and you can use that for your future extensions.
All right. So if you have any more questions, don't forget to mail Attorney Chan Parvathaneni at law@spblawfirm.com. And if you can call him directly in his number 817-523-8247. And also visit his website, spblawfirm.com. It's displayed on the screen. You can note it down. I hope, yeah, just note it down. I think it's easiest. And you could also mail me actually at nipa@highritpeople.com or call me at 408-335-6444. And it was a great session today with none other than attorney Chan Parvathaneni. We spoke about H-1B cap filing and the lottery for 2025 cap, compliance issues, multiple registration issues, and of course, he gave out some recommendations, some suggestions, and we have another question from YouTube by Zuha. What are the predictions for the chances of being selected for H-1B 2025 if the new changes are implemented by the upcoming March?
Sure. So looking at the statistics from last year we had 800,000 registrations, 400,000 were unique. And the year before that, we had about 300,000 registrations. So I think this year, I think there is a little bit of slowdown because we are seeing a lot of job losses, but still there is a lot of heavy demand. And what that means is, I think even this year, I think we can expect 300,000 to 400,000 registrations. We have about 85,000 slots, but USCIS typically they select a lot more than the 85,000. Historically, if you see the statistics, so assuming they will select at least 100,000 and say at least 300 to 400,000 probably apply. My guess is this year we are probably going to see anywhere between 30 to 40% chance of selection because you don't have that multiple registration mess that we saw last year. Compared to last year, I think it's going to be a lot higher. So 30-40% selection rate probably is a lot higher than last year. Last year was terrible because of the 800,000 registrations. So overall, and again, that is, I think, the bare minimum we're going to see. And I will not be surprised if you see higher than that this year, because the way USA has solved the issue of multiple registrations and driving towards the beneficiary centric process.
Right, right. And I think we have more smiling faces after this breaking news, right, Tony? And not just that, I think a lot of people out there are, your fans and they really want to get in touch with you. So we have another question on YouTube from James. I am in India and have stamped H1B from an Indian IT company for their US office. I have not yet traveled to US on this visa. I am on notice period now. Is my H1B uh, can my H1B be transferred?
Definitely, yes. We have done that a lot of times in the past. You are technically you're cap exempt because you have the H1B visa, you have an H1B approval in the past. So normally, what you would do is, when you find an employer, that a new employer will file a cap exempt petition for you in US with council processing, and once that case is approved, you can use that approval. And the visa is not company specific. So your H1B visa, even though it says the company's name, you change the companies. As long as the visa is not revoked, the visa is active, you can still use that same visa along with the new approval copy, and you can step into the country. When you step into the country, let the officer know that you're working for the new company and you have the approval for that company. And typically, you should not have any issue.
Right. And Attorney Chand, we also have a question related to marriage cases. Would you like to take it by any chance?
Sure, sure. Yeah.
Okay, this one is on YouTube by Hurem K. Marriage-based GC in progress, H1B cap exempt valid till July 2025. Once I get GC EAD, do I need to renew H1B in case of GC? In case if GC takes longer than H1B end date to continue employment?
So this is a good question. And what he's saying is, I have an H1B, but I also have a marriage-based green card. I'm assuming the 485 got filed. So the employee's question is, do I even need to be on H1B? The way I see it is probably not, because once you have the green card GC in process and your marriage is legitimate, typically you should not have any surprises, and you will get your EAD card. So in general, I don't think there is a need to renew your H1B unless somebody feels that the marriage is not going right and something might happen. If not, I mean, if the marriage is bona fide, the marriage is genuine, typically there are like less surprises. And again, if you want to keep H1B, H1B is a good backup option if something happens to the GC process. But my experience is, if the GC process is legitimate, the marriage is legitimate, you typically won't have surprises with that part.
All right, Hurem K, all the best. And let's take up the last question from our audience, and that is by Sam Dilton. So Sam Dilton is asking, will the employers be allowed to file physical cases as well, or only the e-filing will be there going forward?
So at least as of this point, because I think everybody is concerned, at least USCI has said, at least for now, for the next anticipated couple of months, they will have e-filing, they will have paper filing. So right now, we have a choice. We can do either. And that being said, I think at least in our law firm, we want to go the e-filing route because it is more predictable. We want to get the receipts quickly. We don't want to have the surprise of missing something in the FedEx. That being said, we don't know because the portal is not live yet. The portal will be live end of February, and we have to see how complex the process is. And historically, our experience, at least my experience with USCIS website is, USCIS, they don't really have a great websites. Their websites are terrible. My experience, especially with the registration process, the registration portal, the website is not that user friendly, and that's why I don't know if the portal is going to be very user friendly, at least in the beginning, because USCIS, they also evolve. They take people's feedback. They see how the process is designed. They take a lot of feedback. They are refining themselves. So at least the initial couple of months, I don't know how seamless or how straightforward the website is going to be. So we want to keep the option open, at least in our law firm. We might do paper filing and e-filing until we are more comfortable. And I think everybody has a choice. They can do either until they're comfortable with e-filing. But down the line, I'm very, very positive that USCIS is working towards streamlining the process So they will make the process right. They will make the process easy. And at some point of time, they will probably cut out the paper filings. Right now, we can do either.
All right, definitely. And all the best, I would say. So keep yourself updated as well and keep on checking the website and the changes they keep updating. And of course, I'm sure you have a lot more questions. I would just say, please get in touch with us and get in touch with Attorney Chan Parvathaneni. His email, phone number, and website is also displayed on screen. And that is mail him at law@spblawfirm.com or just call him directly at 817-523-8247 or just go visit his website, spblawfirm.com. And thank you so much, Attorney Chan Parvathaneni, for this awesome more than an hour session, having so many questions answered and our doubts clarified. And thank you, I would say. Do you want
Thank you
to
so much,
just
Nipasa.
say yeah, thank you. Anything you want to say to everybody watching us right now before we leave?
Sure. I think, thank you for giving me this chance. And not only to me, I think, for the community, I think this is a good community service because we're sharing knowledge. Everybody's sharing knowledge, everybody's sharing their issues. So it's a good way to keep all of us, being on the toes, knowing the law. Everybody is getting educated, everybody's sharing their experiences. So I think this is a great thing. I think everybody's focus should be compliance and follow the rules. And within the rules, there are a lot of things you can do by following the rules. And this H-1B program, I think, no matter. I've seen the Democratic government this time, and previously it was the Republicans, and before that it was again the Democrats. So even if the tomorrow we have elections, this 2024, it's an election year in US. So even if the governments change, it doesn't matter. Both the Republican Party as well as the Democrats, they understand that H-1B program is very relevant, very important to the US economy. So these are highly specialized employees. So I think from an immigration perspective, the H-1B employees, as long as they're following the rules, as long as they're highly specialized, no matter what happens with the political landscape, they are going to be respected, they are going to be highly valued, and US as a country will keep on encouraging them. Only thing is everybody needs to comply with the laws. We have to work within the framework, and I'm hoping that everybody is working within the framework while we achieve our career goals.
So true. So I'll just say keep yourself updated once again, and of course, all the best. Avoid any sort of rejection or complications, by following the rules. The main thing is just that, I guess. And, best thing is to get in touch with an attorney because they are going to give you the best advices and they're going to see you through the whole process. And thank you so much once again, Attorney Chan Parvathaneni, for joining us today. And I'm hoping to see you very soon next week. So, folks out there, I hope you had a good time. Definitely keep commenting. If you have more questions, you can ask us directly. If you want us to even give Attorney Chan Parvathaneni's contact details, you can also get in touch with us. But also, you could mail me at nipa@higherit.com. And my phone number is 408-335-6444. You could visit us at higheritpeople.com. Even if you're looking for a project placement, you could also mail us and at support@higheritpeople.com and visit our website, www.higheritpeople.com. And today it was really fun having Attorney Chan Parvathaneni with us. We spoke a lot about the H-1B cap filing and lottery for 2025, the compliance issues, multiple registration issues, recommendations. He also gave out some tips and suggestions and advices. I hope you got them all right. And even after the show is going to end, it's going to be published. So you could go through the whole show once again and get more doubts cleared, watch more with more concentration, maybe. And of course, we have so much to talk about, but definitely we are the stop for all your immigration and job solutions, I would say. So get in touch with us. And it's Nipasa Pradhan once again saying bye bye for tonight. But I will see you again tomorrow because at 12 noon, because we are going to have none other than Attorney Prashant Dubey as well. So, yeah, stay tuned. And of course, subscribe to us at Immigration and Jobs Talk Show here on YouTube, on Facebook, LinkedIn. And we are simply going to be very happy to get in touch with you and answer your questions and doubts. Thank you so much, everyone. Have a great day ahead. Bye bye.
Bye bye.